Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin. I'm also the managing associate of our Calgary, Alberta office. Here to answer your employment law questions today for the next half hour. Feel free to put your questions in the chat. We're going to try to get to as many of them as possible today to answer anything at all that you have on your mind. We have an early bird, actually. Go Places is already off the blocks with the first question of the day. Go Places is asking me, when calculating severance pay, is overtime pay included or is it just base salary? So you are entitled to be paid overtime pay for your when calculating your severance. Your full severance entitlements include every aspect of the compensation you would have earned had you worked throughout the severance pay period. So imagine you're entitled to a 12-month severance pay period. What that means is from the day you're terminated until 12 months into the future, you're owed everything you would have earned had you continued to work during those 12 months. So like, for instance, in Alberta, we have a lot of oil and gas folks that work tons of overtime. So their termination pay, their severance pay rather, should be calculated, taking into account the overtime they would have been required to work had they worked through that 12 months severance period. All right. And so it doesn't just speak to severance, to overtime pay. If there's any other components of your compensation, you see it a lot here again. There might be a location allowance. There might be, safety clothes allowance. There might be a vehicle and gas card. There might be, of course, benefits, pension contributions, bonuses that you might have earned during that severance pay period. All of that is owed. And specifically when it comes to overtime, you're asking for the value of the overtime you would have earned had you been able to work during that severance pay period. So definitely Go Places overtime pay should be included in any calculation of your severance pay of your severance package. And I see it a lot. People come to me and they're like, well, my employer offered me a great severance package. It's for $100,000 and I make $150,000 base salary. But then you look at their T4 and they're making, 250, right? Where's that extra 100,000 come from? And they'll tell you it's overtime, it's location allowances, all that stuff. And that's not included at all in the value of the offer that they're being given. They're just being given an offer on base salary alone. And you need to know that you're entitled to basically almost everything that's on your T4 should be included in your severance pay. Definitely everything that counts as compensation on your pay stub should be included in your severance pay. Definitely. We have another question coming in from Johnny Walker on YouTube. Johnny is asking us to please cover the reinstatement process of inactive employees on LTD and paid disability. My employer has been shopping for a medical opinion for the past 3 years. Thanks. So I'm not fully certain what you're referring to, whether this is an LTD question or an employment question, Johnny, but essentially what I can tell you from the employment perspective, basically your doctor should be letting your employer know whether you're fit to return to work. And if you are fit to return to work, what kind of accommodations you'll need, what kind of restrictions you have. For instance, you might not be able to lift more than a certain amount of weight. You might need to sit or take breaks more often than normal. So all of that, your doctor will explain to your employer in your return to work plan. All right. Your employer, some do want to say, well, what I'm getting from your doctor is insufficient. I want you to see my doctor that I'm going to pay for. I want you to see my doctor. I want my doctor to tell me whether you're able to return to work with restrictions or not. Honestly, I don't know if you should agree to that. I mean, if your doctor is being responsive, they should have your employer should have all the information they need. It's not just because they pay for the doctor that they get to have a doctor of their choosing tell them what your medical information is. If they have questions for your doctor, if they get a report from your doctor and they still have questions, they should send those questions back to your doctor, right? And if your doctor is being responsive, then I don't see the need for you to see a second doctor. All right. So if that becomes too much of an issue and they're really insisting on you seeing a second doctor, I think it's important that you speak to us first. All right. Because of course, you never know what the other doctor is going to say. And now we have two doctors saying two different things, and you're just stuck in the middle, not knowing whose advice to follow. Best to stick with the doctor that's known you the longest and knows your condition the best. So if that becomes an issue, feel free to give us a call and we can talk about your options going forward. If your question, though, is more about LTD, can LTD make you see their own doctor, or can LTD force you to go back to work or anything like that? I don't work specifically in the area of LTD. I can tell you that tomorrow around this time, we're going to have another one of my colleagues. Darren Saul is going to be here answering both employment and LTD questions. So if you want to put the question to Darren tomorrow, he'll be more than competent to answer your LTD portion of your question. I could really only speak to employment myself. We have a question here from Ashley Burrows. What if your employer is trying to force you into a new position that you can't do? If it's more pay and a better title, are you required to take it? So no, you're absolutely right. So essentially, I'd ask you, it seems that you say you can't do the job. So you definitely don't want to take a job that you're going to fail at. If you don't think that you're capable of doing the job, then you tell your employer, well, I don't want to take this new role. It's a different role than the one you hired me for. It's a different role than the one I've been working at. Either you keep me in my current role, or if that role has disappeared or is no longer available, then just terminate me and provide me with my severance pay. Right now, you can't force them actually to keep you in your role forever. If they don't have that role doesn't exist anymore, then the obligation is that they terminate you with severance. All right. So your choice will then be, well, would I rather be terminated with severance, or would I rather try this new role? All right. And if you try this new role, just keep in mind that you can, ask them that they provide you with training, provide you with feedback so that you can succeed at this role. Because I see it oftentimes, people try out a new job. They've been at a job for, say, 20 years. They're given a new role. They try out the new role. They perform poorly because it's a new job. It's new routines. It's new procedures and all of that. And then they get terminated for poor performance. All right. But before they can terminate you for poor performance, they have to put in the work themselves to train you to do a good job and to give you the opportunity to learn your new role. All right. So make sure that they're upfront with that. Like, what are you going to do for me to make me successful in my role? Those are the kind of questions you have to ask. All right. And be mindful also of signing a new contract if you go into that role. You might be an employee who doesn't currently have an enforceable termination clause, and they might try to get you to sign a new contract with an enforceable termination clause, especially considering that you don't think that you might necessarily be successful in this role, which may eventually lead to a termination. I would say that you shouldn't agree to signing a new termination clause in your employment contract. All right. So just keep that in mind when going forward. But just to go back to the start of the crux of the question, is that if they force you into a role that's materially different than the one that you currently have, that's a constructive dismissal. Even if on paper it's a promotion, it's a raise in salary, they can't force you to accept a promotion. All right, that would be a constructive dismissal if they do that. All right. We have a question here from Everyday I'm Hoodlin. I'm a hoodlin. I really like that name, Everyday I'm a Hoodlin. Good name on YouTube. Just wondering if someone knows if you are still eligible for severance money if you have worked at a place for 25 years, if you decide to separate from the employer. So generally, every day, if you quit your job, you're not entitled to severance. All right. So the only real exception to that is if you're forced to quit for some reason, right? If they've, like what's happening to Ashley, they're changing her working conditions, constructively dismissing her. If they've changed your schedule, if there's some fundamental change to your job that forces you to quit. But if it's just that, I've had enough of this, I have another job prospect that seems interesting, I just want to quit my job, as some people often do, they just change jobs or quit jobs, then no, you're not entitled to severance in that case. I have a question here from Luzia Silvera. I worked for 9 years as a cleaning job. My employer sent me away unfairly and pay only $2,986 but I not accept it. I did not accept. So, Lucia, what I think you're asking me is how much severance you're owed for 9 years. So, actually, I 2,000, just shy of 3,000, does seem low for someone who's been employed for 9 years. But I don't have enough information to tell you whether you're entitled to more, to whether you're entitled to more. But we have a very nifty. I really like this tool, guys. I suggest you take a look. It's our severance pay calculator. It's an online calculator. You can find it at pocketemploymentlawyer.ca. You have the website right there up on the screen. Basically, we're going to ask you 4 easy questions. What's your age? What's your income? What's your position? And how long have you worked for the employer? And from there, we're able to estimate for you how much severance we think you'd be entitled to. All right. So this is only applicable if you're in BC, Ontario, or Alberta, the provinces that we operate in. But if you are in one of those provinces, go ahead in there, take a look, and we'll give you an estimate of what we think your severance entitlements might be. And if there's a big difference between what your employer is offering you and what we're telling you you might be entitled to, then pick up the phone, give us a call. We're here to help you get what you're entitled to if you're terminated. All right. So yeah, let's review that, and just so that you know what you're worth, even if you haven't been terminated, if you're just curious, at your job, if you're thinking of different options and stuff like that, and know what kind of entitlements you have. You've accrued this through the hard work that you've put for these companies. This is a right you have if they terminate you, to have an idea what it is. I have people sometimes, they come to me, well, I've been paid the 8 weeks I'm owed. And I'm like, you're owed a lot more than 8 weeks. A lot of people get confused. They think that the minimum entitlements they're owed under laws like the Employment Standards Act or the Employment Standards Code here in Alberta is all they're entitled to, right? You may be entitled to much, much more. What the Employment Standards legislation sets out is minimum entitlements only that anyone gets if they have a certain amount of years of service, all right? And it's usually about, in Alberta, it's even less than a week per year of service. But honestly, full severance entitlements are oftentimes in the range of a month per year of service or more, and can go up to 2 years of compensation. So you can imagine someone who doesn't know the law, who looks up what they're entitled to under the employment standards legislation, who's been somewhere for 24 years or something. They see they're only entitled to 8 weeks, they take it and leave. They might be entitled to an extra 22 months above that, right? So it's very important you know what your entitlements are. Tell your friends, tell your family, go take a look at the website. It's absolutely no obligation. Figure out what you think your entitlements might be. Go to pocketemploymentlawyer.ca and take a look at our severance pay calculator, so you have an idea how much money we might be talking about. Your termination, is going to bring about a lot of important decisions that you have to make concerning your finances, and knowing what's there to help you, weather the storm is an important piece of financial information that you need to be aware of. We have another question here coming in from TD Allrider on YouTube. How long can an employee be away on LTD and still expect to get their job or a similar position with the same pay when they are finally well enough to go to work? If they can't get their job back, does the company have to pay severance or pay off so that the employee can receive EI until they find another job? That's a great question, TD Allrider. It's true that an employer can at some point, if you've been on LTD, if you've been on disability leave for too long, there comes a point where the legal term for it is there's been a frustration of the employment contract. What that means in layman's terms is that it's not that you don't want to work for them, and it's not that they don't want to employ you, but there's been this intervening event, which is your disability, which prevents the contract, the employment contract, from being performed. All right, from you going to work and earning money for work, right? So because that contract can no longer be performed, the legal term for it means it's been frustrated. All right, and when that happens, it's not that you quit and it's not that they terminated you. In fact, the contract just comes to an end. Okay. And in that case, you're not entitled to severance pay, except in Ontario, you might be entitled to a certain amount of severance pay. Okay. But a lot of employers say that there's been frustration of contract when in fact there hasn't been. All right. For frustration of contract to occur, you have to have been on disability for a substantial period of time. I would say rule of thumb is at least 2 years. And there has to be no likelihood of you returning within a reasonable time. All right. So you need both those things, right? It can't just be, well, it's been 2 years, you're gone. We don't owe you anything. Your contract has been frustrated. And you also need a doctor's note saying, well, listen, the likelihood of this person coming back is zero, right? They're disabled. There's no prospect of them returning to work, even with accommodations or whatever it is. If the employer has all of that, then they can say the employment contract has been frustrated. If they have less than that and they terminate you anyways, then it's actually a regular termination. You're owed severance pay. Now, even if the contract is terminated, you may still be entitled to continue with your LTD, right? I mean, one doesn't impact the other. So if you're still receiving LTD, then you probably wouldn't be eligible for EI. But if you have no LTD and no job, then and they terminate you due to frustration, it may be that you'd be entitled to at least EI disability. So a little bit of a complicated answer to what seems like a straightforward question, but yes, essentially you can be terminated for being on disability for too long. The employer doesn't have to keep you on the books until 65, for instance. All right, but it's not an easy thing for the employer to prove that you can never return. So if that comes up, if you have that issue, if you're reading a termination letter and the employer is saying that you've been away too long, your contract has been frustrated. What a weird word to hear in a termination letter. It's a legal concept. Give us a call. We'll help you walk through it and let you know if we think you might still be entitled to a severance package. Go Places is following up again. Can my employer put me in a performance review plan for not meeting the production quota after 17 years of employment? If I don't meet the quota, can they fire me with severance? So 2 questions. So first, quotas and performance improvement plans. All right. So yes, an employer can have standards. All right. They can have standards of, a quota of a certain amount of, units per hour or whatever it is, and hold you to those standards. Right. And if you're not meeting that standard, then the employer has to do something about it. All right. One thing that employers love to do is jump straight to the performance improvement plan, which is saying, listen, you're at X below quota. We need you at quota within 3 months. And if you're not there, we may terminate you. Okay. And if we terminate you, it'll be for cause and you won't get any severance. Okay. That's one way of doing it. I personally do not think that that's good enough for an employer, especially for someone like Go Places who's been employed for 17 years. The employer and the employee really have to sit down and figure out, why is it that the employee cannot meet the quota? All right. Is it that the employee is not trying hard enough? Is it that the employee has insufficient training, needs new training? Or is it that the quota is unattainable, right? Are other people able to reach this quota? How would this quota come up with, right? And so just putting someone on a performance improvement plan might not be enough. Instead, there may be an obligation that you offer retraining. That you offer shadowing, that you let this employee learn from people who are successful, how they're successful, that you recognize whether there are physical impairments that are preventing the employee from hitting the quota. It's a lot easier for a 20-year-old to hit some quotas than it would be for a 50-year-old, right? So you want to look at all of that and take a holistic approach. And really, the employer can't just be, well, listen, it's, do it or leave. The employer has to show that, listen, we're committed to you and we're committed to your success. We're going to try to help you get to the quota that you need to hit. And if you still can't hit the quota after we've all tried, we may have to terminate you for poor performance. And in that case, it's usually for cause. Now, if they decide, however, they can always decide to terminate you on a without cause basis, in which case you're owed your full severance. Yes. But generally, when you put on a performance improvement plan, they're trying to set you up for a for-cause termination, in which your case you're not entitled to any severance. So be prepared for that, and go places. Try to start talking up and putting in writing why you think you can't hit the quota. What is it that's preventing you from hitting the quota? Is it that it's unrealistic? Is it that you have insufficient training? Or are there any other reasons? Try to have a paper record of your objections. And if they refuse to deal with your objections or your concerns, then that just gives you more credence that they actually then do everything they could to help you meet your targets, meet your quotas, and that they don't have just cause to terminate you. JX2 asks, I'm sorry, I'm getting over a bit of a cold here, so sorry if I'm coughing a bit. In the event your work is affected by fires or other disasters, would your employer owe you severance? I'm in BC, but I know Alberta gets fires too. Sorry. So this is another example, JX2, of the concept of frustration of contract, where it's not that you don't want to work for, the sawmill. And the sawmill, it's not that they don't want to employ you. It's just the sawmill's burned out, right? That's no one's fault. The sawmill is going to try and say, well, that's a frustration of contract. There's no sawmill for you to come and work. That can be a frustration of contract, like it can be. So frustration of contract, you need to understand, it's very fact specific and it's quite complex. All right. So first step, I think if you want to, I'll explain it to you for your own personal knowledge. But if you're seeing in a termination letter the word frustration of contract, your first reaction should be to pick up the phone and call us. All right. We'll tell you if we think that's a real frustration of contract. It gets pled a lot more than it actually does happen. For instance, there was a company that burnt down completely to the ground, right? And 2 years later, they rebuilt the company. They rebuilt the factory. But when the factory burnt down the first time, they let everyone go and said that the contract had been frustrated. And in fact, what happened, by the time one of the employees sued, saying this is not frustration of contract, and the employee won, because basically the employer had every intention of rebuilding this factory, and did in fact rebuild the factory. So yes, so for a period of 2 years while they were building it up, he couldn't work. This employee could not work. There was nowhere to physically work. But that doesn't amount to frustration of contract. All that did was temporarily postpone the opportunity to work. So for 2 years he couldn't work, but it's not that forever he couldn't work, right? That's a difference, right? So if something is closed down, for instance, you're talking about the wildfires in Alberta, of course those people can't go to their work site. There's an evacuation order. That evacuation order is not going to be around forever. So you can't just say, because we have an evacuation order that might last 2 weeks or 2 months or whatever it is, contract's been frustrated. After that's been lifted, if the factory's still there, you can go back to work. There's no problem there. So employers can be quick to jump on the frustration argument without looking is it really now impossible that this employment relationship could ever resume, right? And you got to look at really impossible, not just tough or complicated or hard to do. Like if you can rebuild the factory, you can rehire the people that were working at the factory when it burnt down in the first place. So frustration of contract is not as easy for an employer to argue as they may make it out to be. We have a question here from a Castro on YouTube. The Castro is asking, I'm asking for a week of medical leave in order to care for my husband that is getting surgery. My employer is asking me to sign an authorization document to release medical records. I already provided a medical note and informed they may reach the physician to confirm the surgery. I just don't feel comfortable authorizing them to have access to my husband's nor my own medical records. Is this a HIPAA violation? So if you sign the authorization, then it would no longer be a privacy violation, but they can't force you to sign it. All right. So I'm not sure what province you're contacting us, Castro. I can tell you that the information I'm giving you today is valid in the provinces of BC, Alberta, and Ontario. If you're in another province or in the United States, the information may not be the same. All right, so you should consult a local lawyer. But you're right. Here in Alberta, for instance, there is a compassionate care leave where you can go and take care of your employee. If you have a close family member who needs care, you can take some time off to care for them. And you don't need to disclose all of your and all of their medical records to do that. All right. I think you've personally done enough. You've provided a doctor's note. The doctor explains that you need a week off to care for your husband, who is, incapable of taking care of himself for medical reasons. That is all you really need, right? I mean, the employer has no medical training and should not be second guessing your medical doctor. If you've provided something to the effect that your husband is unable to care for himself for medical reasons and that you need to take care of him, and you provided that medical note to your doctor, to your employer rather, that is all they need. All right, they don't need anything more. So you should be fine to not sign that authorization. All right, we have one last question for today. Sorry. From Sam Lupin. I'm very sorry, everyone. If I am working under a separate employment contract for on-call work that is not unionized, but my other position is unionized, can I speak to a lawyer for the non-unionized work? I'm not exactly sure. What I'm understanding you saying, Sam, is that you have two jobs for two different employers. One is unionized, one is not unionized. In that case, yes, if you have a question about your non-unionized job, you can speak to a lawyer about that. If, however, you work in a unionized environment, but somehow have tasks that are outside of the collective bargaining agreement, I would find that unusual. I would speak to my union rep to make sure that they're okay with that. But if you have two jobs and one of them is non-unionized, and you want to talk to us about that one non-unionized job, yeah, feel free to reach out. So you can reach out to us. We're at employmentlawyer.ca. Employmentlawyer.ca. You can just go on there and start chatting with one of us or one of our representatives to provide you with some information and set up a time for you to speak to one of our lawyers here. Okay, really last question, but here it is. Nothing but me. I got terminated from a new job after only 2 weeks. They did not tell me why. They offered me 3 weeks compensation, no release form. I left my job of 2 years to work for this new company. So I guess what you're asking me, nothing but me, is whether you should be entitled to more compensation. So possibly, it depends, right? Generally, within the first 3 months, if you have a probation clause in your employment contract, then you wouldn't be entitled to anything, really. All right, a probation clause generally says that you can be terminated for just about any reason in the first 3 months of your employment. All right, if you, it is sometimes possible to argue that the work that you had previously should count in calculating how much severance you have if you've been actively recruited by the employer to come work for them. If you've been induced, is the words that the judges use. So if they poached you, if they solicited you to come work for them, and you were just like minding your own business, all of a sudden, listen, come work for us. Here's a job raise. Here's a job. You're going to be with us forever. You can argue that you left secure employment on based on the promise that you'd have secure long-term employment with this new employer. That promise has been broken. You should be entitled to more severance. But again, this can be defeated by having an employment contract that requires that you submit to a probation period. So first thing to do is look, did you sign any employment contracts? Was there an employment letter? Anything like that said that you would be subject to probation, in which case you might be out of luck, unfortunately. Debbie Bergenson is asking, what is quiet firing and is it legal in Alberta? My view of quiet firing is it's another word for constructive dismissal. It's basically your employer making you realize that they don't want to employ you anymore, and why don't you go ahead and quit so that they don't have to pay you severance. All right, that's constructive dismissal. If you followed the show, we talk about constructive dismissal all the time. It's when an employer does something, changes your working conditions, create a hostile working environment, docks your pay, demotes you, anything like that, where they haven't said, listen, you're terminated, but the job that you had is gone, and you either accept this new job that we're giving you, or you quit. Well, you can quit, but still be owed severance because they forced you to quit. So that's what a constructive dismissal is, and that's what I think people are referring to when they're talking about quiet firing. Maybe not in those exact words, but from a legal perspective, I think a lot of quiet firing has to do with constructive dismissal. All right, everyone. Thank you. My name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I was here to answer your questions today on employment law. We have a bunch of more shows this week. Starting tomorrow, we got my colleague Darren Saul will be here answering employment law questions, as well as the disability questions you might have related to LTD and whatnot. So feel free to tune in. Thank you all for your questions. Great questions today, as always. It was great seeing so much interest in the chat, and I hope to see you soon. Bye now.